Since the Netflix documentary Making a Murderer came out, there's been a lot of attention drawn to Avery's case, and as a result, more information has been discovered. In January 2016, People magazine posted an article in their crime section about an interview with Richard Mahler, a dismissed juror from Avery's case. Mahler told People that two of the jurors that convicted Avery were related to Manitowoc County employees. One was the father to a sheriff, and the other was married to someone who worked in the Manitowoc County Clerk's office. That sounds like a conflict of interest. Did the judge and attorneys not know about these relationships, or did they know but not think it was significant? After further research, I found out that it would only be a problem if they did not disclose this information to the court. With these chances being very slim, they most likely told the court this information, and both the prosecution and the defense had to approve the jury, showing that the defense did not believe that the jurors were not impartial. Mahler also told People that while he was still deliberating with the jury, they took a vote during the first day of deliberations, and 7 jurors thought he was innocent, 3 guilty, and 2 undecided. Mahler was released following his daughter's car accident, which was early enough in the case for him to be unaware of how so many of the jurors ultimately found Avery guilty. After the trial ended, he asked another juror how they ended up finding him guilty, and he said, quote, "Just think of all those things he did when he was younger. It seems as if the jury judged Avery based off his character and not off the evidence in the case." Similarly, another juror claimed they voted Avery guilty because they feared for their personal safety. Producers Laura Riccardi and Moira DeMose told the Today Show that they were contacted by this juror and that they believed Avery was framed by law enforcement and that he should be granted a new trial. Time magazine elaborated on this and included that this juror told the filmmakers if they could frame Stephen Avery, they could do it to me. Regardless of Avery being innocent or guilty, this shows that the police had an impact on the jury. The juror also wanted to remain anonymous, showing that they still fear what the police could do. After the documentary came out, prosecutor Ken Kratz wanted to point out how they misrepresented the case. He stated that they left out crucial evidence that led the jury to convict Avery. One piece of evidence he focused on was Avery's DNA that was found under the hood of Teresa's car. Investigators thought to look under the hood after Brendan told them Avery opened it. Kratz claims that the DNA came from Avery's sweat. As a response to the claim that the evidence against Avery was planted, Kratz said, "Do the cops also have a vial of his sweat that they are carrying around? The evidence conclusively shows that Stephen Avery's hand was under the hood when he insists he never touched her car." However, the DNA was never confirmed to be sweat. We talked to a DNA expert from Orange County, Senior Deputy District Attorney Tammy Spurgeon, and when I asked if it is even possible to identify the DNA found as sweat, she said,
No, it's not possible to do that conclusively. So typically when you're talking about sweat, you're talking about touch DNA, and so that's just, it can be left behind from somebody touching an item, with their fingers. Sometimes when you wear clothing, your skin cells will rub off on your clothing and leave DNA behind. But it's usually come from the oils and the sweat, but they can't confirm exactly where it came from. Like if it's from sweat, if it's from tears, they can't say if it's from the skin cells. They can't say for sure.
The DNA found on the hood latch was just identified as nucleated cells, which can be found in any bodily fluid. Therefore, the DNA could have come from any cup or any other discarded item that Avery could have had substantial contact with, making it much easier to obtain and or plant his DNA than Kratz's characterization of police carrying around a, quote, vial of his sweat. To make this argument even more compelling, in Avery's motion for reconsideration, Dr. Carl Reek, a DNA analyst and professional molecular biologist, wrote about a series of experiments his laboratory did on a vehicle with the exact make and model as Teresa's car. He stated that volunteers were enlisted to open the car hood of the surrogate vehicle using the engine compartment hood latch. The latch was then swabbed, and the quantity of DNA recovered by estimated qPCR, the current and identical method used by the Wisconsin State Forensic DNA Laboratory Madison. The test was repeated 15 times, and out of those tests, 11 of them did not leave behind any or enough DNA to be picked up by the detector, meaning that there was less than 0.005 nanograms of DNA. The 4 trials that did leave behind DNA left 0.0519 nanograms, 0.0936 nanograms, 0.0696 nanograms, and 0.0729 nanograms. Therefore, the total DNA found on the latch of the car throughout the 15 trials was 0.288 nanograms. However, the Wisconsin Crime Laboratory estimated that there was about 1.9 nanograms of Avery's DNA found on the latch of Teresa's car. That amount equals more than 6 times the amount that was found on the 15 trials, meaning that Avery would have had to open the hood about 90 times, 15 trials times 6, to get 1.9 nanograms of DNA on the latch. Avery could have opened the hood 90 times, but to us that seems very unlikely. Dr. Reek also conducted experiments to try to replicate the DNA found on Teresa's car keys. Like we mentioned before, the keys were found on the 5th day of the search in Avery's room when the supervising officer was not there. The keys also had Avery's DNA on them, but none of Teresa's DNA. Dr. Reek wrote that in the experiment, an exemplar key, reportedly held by Mr. Avery as if to start a car, i.e. gripped by ungloved fingers for 12 minutes, was subject to qPCR analysis, i.e. DNA quantification. It was determined that 0.017 nanograms per microliter was recovered. This result was 10 times less DNA than reported by the Wisconsin Department of Justice State Crime Laboratory Madison on the key they analyzed. Once again, the amount of DNA found on the exemplar key is significantly less than the amount found at the crime scene. It is very unlikely that Avery could have gotten that much of his DNA on Teresa's car keys when absolutely none of her own DNA was on them. One other thing Kratz continually spoke about was the bullet found in Avery's garage. Like we mentioned before, the bullet had Teresa's DNA on it and was not found until the second search on March 1, 2006, after Brennan's confession. The rifle that the bullet came from was confiscated by officers during the first search back in November 2005. Kratz denies the theory that officers planted this evidence and told the New York Times, if they planted it, how did they get a bullet that was shot from Avery's gun before November 5th? In response, defense attorney Strang claimed that the bullet fragments were all over the property as the family always shot guns. In May 2017, Dr. Christopher Palahniuk, a senior research microscopist at Microtrace LLC, examined the bullet for the presence of bone. He first took 4 exemplar bullets, fired them through bone, examined them, and then sent them to independent forensics for DNA extraction. Before he sent them to DNA extraction, he documented white translucent particles that were consistent with the presence of bone on the surface of the bullets. When the bullets returned from DNA extraction, they still had these white particles on them, showing that DNA extraction would have no effect on the presence of bone on the bullet. When Dr. Palahniuk examined the bullet found in Avery's garage, he found that about 40% of the bullet was covered with a waxy surface that he suggests could be from the firearm analyst who originally examined the bullet. There were also numerous fine red flakes, a few fibers that were mostly colorless, a large amount of wood flakes in, on, and under the wax, and no particles consistent with bone. Dr. Palahniuk said that these particles could be examined and analyzed further to find their specific origin if it is necessary to the investigation. He also concluded in his affidavit, based upon our analysis, there is no evidence to indicate that the bullet passed through bone. In fact, the particulate evidence that is present strongly suggests an alternate hypothesis, which is that the trajectory of the bullet fired took into a wooden object, possibly a manufactured wood product. Furthermore, the presence of red droplets deposited on the bullet suggests that the bullet had picked up additional contamination from its environment at some point after coming to rest, i.e. droplets of potential red paint or red liquid. This completely contradicts the prosecution's claim that this bullet went through Teresa's skull. Zellner wrote in Avery's motion for reconsideration, Dr. Palahniuk did detect an abundance of wood on the bullet, which makes Mr. Avery's allegation that Miss Halbach's DNA was planted on the bullet beyond question and unrefuted. Zellner also sent an investigator to Avery's garage to look for possible sources of the particles that were found on the bullet. There they found a wooden particle board with apparent bullet holes and a few red-painted surfaces, including a red ladder and a red-painted ceiling. This evidence does not necessarily show that Avery is innocent, but it does show that the bullet never went through bone. And if the bullet never went through Teresa's bone, how is her DNA on it? Most of the information I just told you was actually included in Avery's motion for reconsideration. This was filed in an attempt to get their previous motion for post-trial relief reopened. Whenever new information or evidence comes into light after a trial that may have influenced the jury's decision, the judge is supposed to hold a hearing. At that hearing, the judge will then see if the new evidence is something that would have changed the jury's verdict. In Avery's case, even with all the new evidence and technology, the judge still denied a hearing. They believe that there was no information that could have changed the verdict. As of right now, Avery is still in prison while his attorney fights to get him a retrial. As for Brendan, he is also still in prison. Back in August 2016, federal judge William Duffin overturned Brendan's conviction and ordered that he would be freed in 90 days due to the unreliability of his confession. However, the prosecutors appealed and the 7th Circuit Court of Appeals in Chicago reversed the grant for a new trial. His attorneys are currently petitioning for his trial to go to the Supreme Court. If it gets accepted and they throw out his confession, he will be retried without it. If the state chooses not to retry him, he will then get to go home. So, I'm sure by now you have figured out our position on Avery's case. We tried our best to present all the evidence in an unbiased way so you could formulate your own opinion on Avery's innocence or guilt. We believe that Stephen Avery is not guilty and that the evidence against him is planted. In an attempt to answer who did it, we present you with a possible suspect, Ryan Hillegas, Teresa's ex-boyfriend. Teresa took both verbal and physical abuse in their relationship with Hillegas. At the time of her death, Hillegas was unemployed and visited Teresa frequently. The day before she died, he was at her house and gave authorities little to no information on when or why he was there. He also had absolutely no alibi from October 31st to November 3rd and was never asked to give one. Hillegas had motive to kill as Teresa was briefly seeing his best friend, her roommate. It has been said that she was in a sexual relationship with her roommate, Scott Blodorn, which he lied about on the stand during Stephen Avery's trial. There is also evidence that after Teresa died, someone went on and deleted her voicemails. Teresa was known to always be on top of her voicemails, and if the mailbox were to be full, people would be suspicious. In order to access her voicemail, the killer would have had to know her password. Hillegas knew her username and password and even helped law enforcement access her account to obtain her phone records. Also, when the RAV4 was found, it had a broken front blinker light on the driver's side, which Hillegas told the police she had damaged, filed a claim, and then took a cash payout for months before. However, there is no record of an insurance claim, and it is said that the damage occurred after she left Avery's property on October 31st. There were also several occasions where Hillegas went by the name Mr. Kilgus to enter the property, and the day before the bones were found in the burn pit, Hillegas entered the property without signing in at all. He was seen on TV as having scratches and cuts on his hands, which was analyzed by a pathologist to be consistent with scratches created by fingernails. Teresa could have easily scratched him in her attempt to get away. Hillegas also had possession of a page of Halbach's day planner after she died. Her day planner was in her car at the time of her murder, but in Ryan's possessions after the murder. How did he get her planner if he was not a part of the murder? Although we don't know if he did it for sure, we do think that he needs to be looked into as a suspect. We also believe that Stephen Avery was wrongfully convicted of this crime. And even if he did do it, there was certainly not enough evidence that he committed this murder beyond a reasonable doubt. Thank you for listening to our podcast. We hope it gave you a glimpse of how much we've enjoyed learning about forensics this past year and provided our take on how one can determine a reliable understanding of truth within the criminal justice system.